propriety, or shall I put it higher and say the constitutional manner in which the National Assembly exercised its power. It says it did so unconstitutionally because it didn't exercise the discretion that it had, believing it didn't have that discretion. Now, while the full court here in paragraph 58, addressing the exercise by the National Assembly of its designation power in relation specifically to the second applicant, the implications or effects of the exercise of that power cannot legally be limited to the second applicant. And this is very simple, Justice Wilson, because the exercise of power is either improper or it is proper. It is not the challenge to that power that renders it improper. Because a suggestion has been made by the respondents that only the designation of the second applicant has been challenged in court, and therefore that was what the full court was concerned with. And in fact, that is what the review court is going to concern itself with. The other 5 designations have no relevance in this case. But we say the full court actually found that in failing to exercise its discretion under 178(1)H properly, effectively, the National Assembly acted unconstitutionally. If that is the finding, then the designation of all 6 is tainted by the unconstitutionality and impropriety of the exercise of that power. The fact that there has been no challenge to the designation of the other 5 designates does not render the decision or the exercise by the National Assembly of its constitutional power proper. So let me sum up. It is the exercise of the power, the constitutional power by the National Assembly, that is improper. It is not the challenge to that exercise that renders it improper. And therefore, the fact that there has been no challenge to the other 5 doesn't render that decision, which is improper, or that exercise, which is improper, suddenly proper. More indications of the broad nature of the full court decision in relation to the exercise of the National Assembly's designation power are these, and I'm just going to give snapshots. In paragraph 59, the court takes general terms, not just confined to the second applicant or his designation, about the fact that the National Assembly followed a convention that a party's nomination to the JSC is simply accepted. And finally, in paragraph 64, nothing could be clearer. In paragraph 64, the full court says, and I quote, "It is evident from the papers that the National Assembly fails to appreciate that it had a discretion in designating MPs to the JSC, and consequently, it fails to exercise such discretion and did not rubber stamp," and here it goes to the MK's nomination of Dr. Hlophe. But as I've already pointed out, if the finding, as it is, of the full court is that the designation is tainted by a failure properly to exercise its constitutional power, then that taints all 6, not just the 1. Where are we going with this? We're saying that these indications make plain that the full court was talking about the exercise of the power in general, not just in relation to the second applicant. Can I then jump to dealing with the requirements for an interim interdict. How much time do I have? Sorry, I haven't been checking my time. Yeah, but I need to know 10, 15. Okay.
And I suppose the question that's going to go on is how that critique of the full court's judgment connects with the discretion the JSC exercises continue next week.
Exactly,
I'm not sure the JSC could be expected to go behind the full court's order.
quite right.
Let's assume the JSC decision-making body uniformly felt that the full court's order and judgment were wrong.
Yes.
I'm not sure that the JSC would have been at liberty to give vent to that view in deciding whether or not to proceed next week. What it had before it was an order that's saying that Dr. Hlophe can't participate on an interim basis in the JSC's proceedings. And had to treat that as a brute fact.
Yes, no, I appreciate
the fact
that.
of the order, whatever its effects on, there's a lot of argument about whether it's interim, final, and whether giving effect to it would affect the Constitution as opposed to the forum of the JSC. And that's where I understand the action in this case to be.
Yes.
But the fact of the order, the JSC just had to take the given, didn't it?
Yeah, Mr. Boff was baiting me, saying, "I'll deal with that. I'll deal with that." So I'd best defer to him. But what I'll say is this: the tie-up between the meaning of the proper interpretation of the full court decision to this interdict is set out. Well, the relevance comes in the balance of convenience and irreparable harm part, and I'll come to that in a moment.
Yes.
We say in relation to the right that the second applicant has a clear, not just a prima facie right, a clear right to participate in the JSC as a duly designated member of the National Assembly, and that the full court, in interdicting his participation in the imminent proceedings beginning on the 7th of October, simply does not detract from that designation to the JSC. I don't think there is any controversy on that issue. All it does is merely to disrupt his participation in the imminent proceedings beginning on the 7th of October. It doesn't nullify the right, as one of the respondents contend.
Well, as the JSC person, he's still designated JSC, he's still a member of the JSC.
He's still a member of the JSC.
The court order saying he can't participate in the proceedings until Part B of the matter in the full court comes to fruition.
Exactly, but we say, but he has a constitutional right to participate in all proceedings, including the 7th of October proceedings, as a properly designated member of...
If you want to obey the full court's order, you've got two options. Either proceed without him, or don't proceed at all.
Exactly.
Or
as we ask to suspend. Yes. And we're not saying they must stop forever and anon. This is not an indefinite interdict. It's to stop until the cloud of uncertainty as regards the propriety or the constitutionality of the designation has been determined in Part B. Of course, there could be negotiations among the parties about how to speed up the process of dealing with Part B. It doesn't have to take years, as some of the respondents have alluded to. So, on a proper interpretation, Section 178(1)H of the Constitution confers on the opposition parties the right to nominate and have designated the Judicial Service Commission at least 3 of their number. It is not for a party in government or a non-governmental association to determine or dictate who in the opposition must serve on the Judicial Service Commission. That is the right, a political right that the second respondent has, supported by his political party. Now, in relation to the reasonable apprehension and balance of convenience, we're saying there is no doubt that the balance of convenience favors the granting of an interdict or the suspension of the JSC proceedings until determination has been made of the lawfulness of the designation by the National Assembly. The difficulties or prejudices that have been identified, litany listed by the Judicial Service Commission and Freedom Under Law, the second applicant is well aware of these. I mean, after all, he has been a judge president for more than 3 decades, I think, so he understands the challenges of the under-resourcing of the high courts. But non-constant that one addresses that by running the risk of rendering decisions that could end up being declared to be unconstitutional. So if one weighs up, on the one hand, the temporary suspension of the proceedings of Judicial Service Commission, I would even venture to say this, and I haven't discussed this with our learned friend for the first applicant, but if one were to conceptualize something like a structured interdict order that says the interdict or the suspension will hold for a limited period, say 6 months, subject to either party approaching the court within a certain period, either to discharge that order on good cause shown or to extend it. And then the court hearing that application will then determine which side to fall on. So that is one way of dealing with the suggestion that this is an indefinite.
So if the JSC proceeds without Dr. Hlophe, its proceedings may well be later be impugned because he isn't there, or because the basis on which the full court decided he shouldn't be there also applies to the other 5.
Yes.
Or both.
Yes.
Which one of those 3 propositions is it?
It's all 3.
Yes. Well, I'm not sure if 3 is compatible with 1 and 2, but it's both, effectively. If Dr. Hlophe doesn't go, you say that might well taint the JSC's proceedings, and you say the indication in the full court judgment is that participation of the other 5 National Assembly designees may well in future be held to have tainted the JSC proceedings.
That is correct, and that's...
And it's relevant, you say, to balance of convenience, because that the potential that the JSC that carries on for 6 months or a year while this is sorted out,
exactly,
suddenly having all of its acts set aside, tips the balance of convenience radically in favour of granting this.
You have it exactly, Justice Wilson. So I shan't belabor that point. I'll move on to the next issue. The next issue is the absence of alternative remedy. That really is an issue that my learned friend for the first applicant will deal with, because it looks at the application or otherwise of Section 18.2 and 18.3 of the Superior Courts Act, whether this is the kind of case which which is relevant here. If the second applicant is excluded from sitting on the JSC proceedings this October, the second applicant will have no remedy against an event that has already taken place. and review proceedings of the nature of the Premier when Helen Zille wasn't part of the deliberations on the second applicant would be unlikely to apply here to set aside appointments that have already been made, because a judge, as Justice Wilson will be aware, a judge can only be removed on one of three instances: gross incompetence, gross...
I looked it up before I took the job.
Yes. So those are the only three requirements. A court cannot, or the President or the National Assembly cannot remove a judge on the basis that he was unconstitutionally appointed. So there really is no alternative remedy. And we say we've been accused of not having raised the outer grounds. We say, really, if one looks at the manner in which the second respondent's case has been pleaded, beginning with the proper interpretation of the rule of the full court, looking at the implications of the Judicial Service Commission sitting regardless of what appears to have been the finding of the full court, and looking at the implications of the full court decision itself, we're saying this presents clear, more than a clear instance where an interim order of the nature we seek should be granted, and exceptional circumstances. Unless there's anything else, those will be the brief submissions. I hope I've stuck to my time.
You've more than stuck to your time. Thank you, Mr. Nawaz.
Thank you, Justice.
That means you can have 15 minutes of Mr. Nawaz's time.
20. Now, he would have been up to 10:50, so mine will be 11:35.
Well, let's then carry on until
and make tea at that time.
Yeah.
As the court pleases.
Unless you'd like a break.
My letter, I'll indicate if I do.
Yes.
But
carry on until what, 20 to noon?
Yes, 22, my lord, yes. Yeah. And if I need a 15-minute wrap-up break or whatever, I'll indicate maybe before half past. My lord, I'm indebted to the court, and I'm indebted to my learned friend, Mr. Ngalwana. And my lord, I just want to take one step back and raise some of the issues, just wrap up on some of the issues that Mr. Ngalwana has raised, but in the context of situating the whole case.
Yeah.
So, my lord, the structure of this case is actually very simple, and I'm doing this really because from the reading of the answering affidavits and the heads, it is my respectful view that some of the respondents actually don't appreciate the nature of the case, and maybe that's our fault, so it's my obligation to just spend 2 or 3 minutes to explain. I say so because you'll find, my lord, and this is a criticism that we make, for example, of the JSC, as we say that 90%, and that's obviously not a scientific estimate, of their focus is on this interim interdict.
Yeah.
Everyone out there is saying, controversies when Dr. Hlophe are here to interdict. And we can understand why that seems to be the case. But the reality, my lord, is that this case, the interdictory relief, as your lordship pointed out to Mr. Ngalwana earlier, is actually the alternative. So this case cannot be about the alternative relief. The primary case that we bring here, my lord, is prayer 2, which is the declarator. And the reason why everybody is running away from the declarator in our respectful submission is because it's actually unanswerable. And you will find, my lord, that in fact, it's interesting. FUL goes on for pages and pages trying to attack the declarator, but with no substance at all. The JSC takes the exact opposite. They just refer it in one sentence. They say no, an interim interdict cannot, or rather, a declarator cannot be equal to interim relief. And that's it. That's the sum total of their defense to the declarator. Now, the issue then, my lord, is this. If we then situate the case in its proper perspective, then your lordship will realize that all these pages and pages that have been spent here about balance of inconvenience, this and the other, the impact on the judiciary, and what have you, are actually completely irrelevant in the consideration of the relief that we come to seek here. They may become relevant, of course, if your lordship finds against us on the main relief, and then we have to interrogate the issue of the alternative relief sought. But you can't argue a case by turning it upside down and then saying, no, but the alternative relief is bad. But so what? Because we may never get there at all. So that's the first thing. The second thing, my lord, that I want to say by way of prefacing is that now, if we then focus on the real case, which is the declarator, how Mr. Ngalwana's section and mine combined is as follows, and the lordship again foreshadowed this by a question a few minutes ago. So Mr. Ngalwana's primary focus on the interpretation point is that the constitutional impact of the Western Cape High Court order is that, and its proper interpretation is that it taints all six. And he has made submissions. The lordship has interacted with him. There's no point in belaboring that. We agree, obviously, with that. Our focus on the interpretation point, my lord, is that even if Mr. Ngalwana's interpretation is incorrect, the absence of Dr. Hlophe alone has the same constitutional impact, the same nullifying impact on the composition, and I'll develop that point now. Now, some of the indications, my lord, of the, just to wrap up, if your lordship goes to the paragraph that Mr. Ngalwana read, paragraph 64, you'll find that at 02-69 of the judgment, my lord.
Yes, paragraph 64, you say? Yes,
paragraph 64, my lord. In addition to all the other indications that Mr. Ngalwana indicated, that this is a designation of the delegation per se, and I'll explain why I use that word as shorthand. You'll see that even it is evident from the papers that the NA failed to appreciate that it had a discretion in designating MPs in plural. So that's really the crux of the interpretational exercise. So, my lord, I use what you call a collective noun, say a flock of birds and so on. So, for shorthand, the collective noun we have to use for this is a delegation of designees. Yeah. Correct. Thank you, my lord. Then that's going to assist us. So, if we look at it like that, we say what the NA was doing was to pass a resolution, one resolution, for a delegation of the designees per se. Then that's the end of Mr. Ngalwana's point. It's very clear. And if that is so, my lord, if this is a delegation or a squad or a team, whichever collective noun you want to use.
We settled on delegation.
Delegation. I'm happy with that, my lord, as well. Yes, because I saw in some dictionary there were like 70 of them, a swarm of this and a gang of this. But nothing delegation will do. Thank you, my lord. Now, If we accept that, then, my lord, it creates the following two problems, and I'll raise this in relation to the SCA cases. Remember, there's this whole debate about the SCA cases and the court and the full court here.
You're referring to the full court decision
In Hlophe.
Division about whether Dr. Hlophe in a previous guise was essential.
Yes.
It was an essential attendee.
Yes. No, in fact, it was raised by him, my lord, to say that the absence of the president or deputy president of the SCA.
Oh, I'm sorry.
Yes. That's the one. Sutherland TJP's judgment. Yeah.
We're talking about the same judgment.
Yeah, we're talking about the same judgment, my lord. And how that judgment, as your lordship will remember, then related to the two SCA judgments, which are key to this. One being the Premier of the Western Cape judgment, the second one being the Bar Council, Cape Bar Council case.
So as I understood the decision in this court, it was that absence for a good reason,
a justifiable reason, yes,
wouldn't vitiate the proceedings.
Yes, yeah, in a way, my lord, yeah. And I'll come to that.
If you're ill, for example.
Yes.
And you have an alternative.
Yes, or you're stuck, yeah. As someone who once sat in the JSC, that happens quite a lot, my lord. Now, so, my lord, the case really is about two concepts. You know, you can have all these papers, but there's usually just one or two organizing concepts of a case. The organizing concepts of this case, my lord, are two. One is interpretation. And by that, I mean interpretation of the court order, part of what Mr. Galane has done, the interpretation of Section 178 in particular, and the interpretation of the Bill of Rights, the fundamental rights that we invoke, including Section 19 and so on. But that's really what this case is about, is the interpretation first. The second one is the one your lordship has just touched on, the second organizing principle. And I call it for shorthand again, unjustifiable exclusion. As we as lawyers know, unjustifiable enrichment. So we're creating a new topic called unjustifiable exclusion. If your lordship is with us on those two issues, the interpretation and the unjustifiable exclusion issue, that's the end of this matter, my lord. Now, let's go to back to the interpretation point. And your lordship, as your lordship knows, sometimes it helps everyone, including the opponents and the court, to make it clear what we're not saying, rather than what we're saying, because we've been accused of all sorts of things, including wanting to collapse the whole system. My lord, you will find from all the respondents that they make two fundamental mistakes about what we are saying, and I want to disclaim any of that up here. The one thing is that we are raising here the same arguments that were raised in the Western Cape High Court. That nothing could be further from the truth, my lord. How could that even be, conceivably? That case, we were respondents being attacked by the applicants, or some of them at least, except Mr. Manager client. And the issue there was a simple one, whether an interim interdict should be given against the self-same sitting, and so on. So the issue which is before this court about the postponement or non-postponement of the JSC could not conceivably have arisen there at all. The second one, which is even more gutting, is that, no, this is nothing but a backdoor appeal of the Western Cape Full Court judgment. My lord, honestly, how could we, even if we were creative, seek that your lordship here, by some measure, sitting alone, is going to overturn the judgment of the Western Cape High Court? It's impossible.
Well, I understand it to be common ground between the parties. The full court's order stands.
Absolutely.
Fact. The question is whether the JSC responded lawfully and rationally to that fact.
Thank you, my lord.
And so the focus, that's why I put to Mr. Ngolwana, the focus must be on what the JSC ought to have done.
Absolutely.
Recognizing that it can't go behind that order.
Yes, absolutely.
Or criticize it in any way.
Yes.
Any more than I can.
Absolutely, my lord. And more than I can. At least not here.
Yes.
No, thank you.
I think you reserve your right to do
yes,
so. when
I have to
appropriate.
reserve my energy
Yeah.
for the Western Cape High Court.
Yeah.
Thank you, my lord. Then half of what I was going to say is done. And just in case there's anybody who has any doubt, my lord, I want to say it here in public that for the purposes of this court and the purposes of this application, this court has no option but to take that judgment as granted. Even if your lordship read the judgment and said, I've never seen any judgment so bad, there's nothing you can do about it, there's nothing I can do about it, and there's nothing anyone can do about it.
So just on that point, can we clear up an ambiguity in the papers about the effect of the application for leave to appeal?
Yes, my lord.
Is it your case that the filing of your application for leave to appeal suspended the operation of the order?
It is, my lord.
Yeah.
And let me explain and how it fits into...
So while I must accept that it's a fact,
Yes.
what you urge me to accept, that the order was final in effect,
Yes.
and the filing of the application for leave to appeal suspended.
Yes, that's correct.
And the irrationality you impute to the JSC is that it just didn't appreciate
Didn't recognize that fact, among other things. But, my lord, your lordship is making my job much easier. Let's go there, because that's the third interpretation point, as it were. I'll deal with it very quickly. What we are saying, my lord, and this is again, I've dealt with this Section 18 things many times at different levels, and there are always these common problems around it. Remember, the difference between us and the respondents is that this is an 18.2 event, and we say it's an 18.1 event, as your lordship just summed it up.
Yeah.
Now, these are the simple reasons we say it's an 18.1 event, my lord, is your lordship will find the actual wording of the, of the sections in our notice of motion and our funding of the, I think it's 02-60 something.
Yes, I have the act in front of me. You don't need
Oh, perfect. Okay, fine. Let me also just another do that here. So let's start at 18.2, my lord, and just read it together. So 18.2 says, subject. Okay, the two things define whatever the default position is.
Yeah.
Subject to subsection 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order, not having the effect of a final judgment, which is the subject of an application for leave to appeal, is not suspended pending the decision of the application or appeal. Now, all we're saying, my lord, we concede that when we wrote the letter on Monday, this Monday, the applications for leave to appeal were not in. But we obviously indicated that they're coming, and as soon as they came, we sent them. In fact, I think, if I'm correct, subject to correction, by the time the JSC had its meeting, we had already lodged.
Yes, well, in its letter, the JSC refers to Section 18.2.
Yes.
And so I think...
So they must have, yes.
I think they must have
Yes,
appreciated that either their decision had to be taken on the basis that the appeal would definitely come, or that it had already come.
Absolutely.
Yeah.
As the court pleases, my lord. And I want to kill two birds with one stone, as we discussed this, my lord. The first bird is to answer your lordship's question as to why we're saying it's an 18.1 or 18.2. The second one comes from what your lordship's remarks just now, which is why we assail the JSC decision on this point. In other words, we're saying on this point they made a material error of law. And as your lordship knows, material error of law leads to irrationality or illegality.
Well, if they made an error that's as basic as you say they did,
Yes.
then that definitely
That's it.
renders their decision
Yes,
irrational.
absolutely.
There might be some highly complicated
Explanation.
terrain in which an error of law doesn't lead to irrationality,
Absolutely.
but I can accept for the purposes of this case it does.
Yes,
Yeah.
absolutely.
If there is such an error.
Yes, if a big if. Yes. Thank you, Madam. Now, so since we're on the same page on that, my lord, let me then explain this in simple terms. So we say there are two exceptions which are contained in 18.2 that assists us in our interpretation.
Yeah.
The first is the word interlocutory order. A decision that is an interlocutory order.
Yeah.
Many people read that to mean an interim order. But that's not the same thing. Because as your lordship knows, there are interim orders and there are interim orders. And that has been explained in a case that I did called Libashe that everyone knows. I think it's the most recent.
The section itself appreciates that there may be interlocutory orders of final effect because it only applies in circumstances
Absolutely.
where there's an interlocutory order not having the effect of a final
Absolutely.
effect.
Yes, and that's the second point.
Yeah.
So we're saying, my lord, forget about the final effect for a minute.
Yeah.
If it's not an interlocutory order, even if it had or didn't have a final effect, that would favor us. But secondly, as your lordship correct, let's assume we're wrong on the interlocutory order thing. If it has final effect, then it's excluded as well. Now, so we say on both legs, my lord, that favors us. And every lawyer, and I'm sure my learned friends will be no exception, will accept that if there's an application for leave to appeal and you can discount 18.2, then by default, then you are in 18.1.
Yeah.
So that's our argument. So our argument is simply this, my lord, that because of the operation of those two exceptions, we're in the 18.1 land. And once we're in the 18.1 land, contrary to what all our learned friends are saying, no, why, even on alternative relief, why don't you go to 18.3? No, it's them who should go to 18.3. They are the ones who have a duty, if they don't want to the order to be suspended, to do an 18.3 application. Thank you, my lord. I'm not going to belabor that point anymore. The court.
Yeah.
I'm not saying the court agrees with me. It understands.
I have the point.
Yes.
Thank you.
Thank you, my lord. So that's a huge interpretational point on the one hand, but secondly, an attack on the reasoning process of the JSC. So I want to do it one by one. Now, my lord, if your lordship allows me to then, I'll do another double take to demonstrate to your lordship that what we are talking about, while accepting for the purpose of this, what your lordship correctly called the fact of that order, that we accept. But what this case is all about is about the constitutional effect or the constitutional impact of that order. We're not attacking the order. We're simply saying its constitutional impact results in the JSC as matters currently stand being improperly constituted. That's really all. It's that simple.
And that's the second basis on which you assess
Yes.
the JSC's decision.
Absolutely.
JSC ought to have appreciated that it would be improperly constituted if
Absolutely.
proceeded.
Yes, and if you look at their letter, my lord, you will see that actually is the main material error of law, as it were. For them, the main.
They essentially say you're still Dr. Hlophe is still a member of the JSC.
So what's the problem?
He just can't come.
Exactly.
Yeah.
Well, that's what they're saying. Whereas, in reality, my lord, if we are correct on this point of the constitutional impact, and let me, if your lordship forgives me, let me just quickly get rid of no, I'll deal with it when we deal with the exclusion.
Yeah.
Let me stick to the constitutional impact. So, if the constitutional impact of that valid order of the Western Cape High Court is to create an unconstitutional situation, a situation that is inconsistent with the Constitution. If I succeed in persuading your lordship that the situation created is inconsistent with the Constitution, then your lordship has no option because Section 172(1)A says you must. Once I can show that constitutional inconsistency, Your Lordship must declare that conduct to be unconstitutional.
Well, we get to the same result if I concluded that the JSC had acted irrationally.
Yes. No. Actually, my Lord,
that would be in breach of Section 1C.
Absolutely. In fact, my Lord, and I'm glad Your Lordship asked that question, because again, it's misunderstood. That's the difference between Section 38 of the Constitution and 172. The Lordship has hit the nail on the head. Some people confuse the two. Section 38 deals with an infringement or threatened violation of a right in the Bill of Rights. Right? But Section 172(1)A, as Your Lordship has correctly summed up, deals with the inconsistency with the Constitution, not just with the Bill of Rights. So any section of the... So that's the difference which is usually misunderstood. And Your Lordship is 100% right. Whether it's Section 1C or Section 200 or Section 300 or whatever, if you are able to
I'm trying to work out whether there is
know there
Section
isn't.
300.
Yes. No, the Lordship is definitely on point. But I'm exaggerating for effect.
Yes.
So I'm saying, my Lord, whatever section of the Constitution is violated, or once that is established, of course, that's the gateway. Once that is established, then and the constitutional writers, my Lord, were it was a deliberate way to phrase 172(1)A as opposed to 172(1)B, because that's what constitutional supremacy is. We can't say the Constitution is supreme, and then we say a court has a discretion.
Well, it seems to me the 172 duty is to declare any conduct that is inconsistent with the Constitution to be so.
Absolutely.
But then there's a wide remedial description about what a court does.
What to do, yes. In fact, sometimes a court may do nothing. but what a court is enjoined to do constitutionally, it's a duty, a constitutional duty, is once established, it must declare. And that has been said, my Lord, if you, Your Lordship, allow me 1 minute to digress as to why that is so. One is constitutional supremacy. We've dealt with that. But the second one, which is always forgotten, is something called the doctrine of objective constitutionality. Now, that's just a lot of big English. But what it really means, my Lord, is that when the court does that and makes that declaration, it is not declaring the conduct of the JSC to have been unconstitutional last week or on Tuesday when it had a meeting. It's declaring that that conduct is unconstitutional since 1996. That's so it's...
Unless the retrospectivity is...
Absolutely, yes. That's why sometimes the court then ameliorates that, yes. So it is that serious. That's why we have something, my Lord, another misunderstood concept called the Gijima principle. And it goes like this. Once a court has a 172(1)A issue in front of it, it must, even in the face of unreasonable delay, in the face of mootness, and all these other niceties, that court, according to the Gijima principle, still has to grant the order. Why? Because all these niceties notwithstanding, a court cannot go back to chambers to put it to demonstrate it and leave an unconstitutionality sitting on the table simply because it took me 6 months or whatever. It's that serious because that implicates the supremacy of the Constitution. Now, that then puts a burden on me, my Lord, to convince Your Lordship that there is indeed an inconsistency with the Constitution. Not in the full court, in the conduct of the JSC, yes.
So the two points you've made so far are that the JSC misconstrued the effect of the order, and that it misconstrued the impact
of Section 18
of excluding Dr. Hlophe from the proceedings.
Yes.
Is there any further point?
Yes, and Section 18. You remember we just discussed.
But doesn't that really collapse back into final or interlocutory effect of the order? If the JSC thought that the order was into the Q-tree in effect when it was only final, when it was actually final in effect. It doesn't. The issue about whether 18.2 or 18.1 or 18.3 apply falls into that misconception, doesn't it?
No, my lord, with the greatest respect. If it's much more serious than that. It is that, of course, but it's more serious than that. My lord. It has two serious impacts. It says that the JSC, when it was given, remember the JSC is an organ of state. So
that's the better way to put it. Sorry to interrupt you, but the better way to put it is your case is that the JSC failed to appreciate that the order was suspended by the applicant.
Absolutely. And in doing so, as we discussed earlier, committed a material error of law.
Yeah.
And if the JSC's decision is irrational, then the Lordship has no option but to...
Then there's the constitutional impact of proceeding in Dr. Hlophe's absence. Is there anything else that in your submission vitiated the rationality of the JSC?
Yes. Yes, my lord. Okay, let me put it this way, my lord. If your lordship allows me, I won't answer the question directly. I just want to start at the end. One of the giveaways, and we say this, unfortunately, your lordship hasn't seen our reply, but your lordship will find in our reply that one of the things we say is that one of the giveaways that the JSC's decision was irrational is something that is said by one of its commissioners, Mr. Hlophe, in his supporting affidavit.
Yes.
In that, he actually says, my lord, and your lordship will find that in section 6, page. Anyway, my lord, let me paraphrase to save time. Your lordship will take your lordship there. But this is
well,
what
I have it here. It's 06-287.
That's 287.
Yeah.
Yes, my lord. All right, I'll get to it. Let me just paraphrase. Your lordship will read it in. Well, there's no good time. I was going to say in good time, unfortunately.
No, but I have already read it.
Yes.
So
Okay. Thank you.
To the part of it. Just while we're on this point, I still don't see the replying affidavit on case lines. If someone on your team could sort that out.
Yes, Martin is here.
Yeah.
Can we just reload? That's good, please.
Thank you. And if you can't sort it out for any reason, just email us.
We'll give you a hard copy.
Yes.
In due course.
Yeah.
Now, there's your lordship. Again, I won't bore you with all these authorities. Your lordship will know the cases, the line of authorities, National Lotteries Board. There's a case of Zuma versus the DA and so on. It's all in our heads. But the gist of those cases, my lord, is this. The first one was Kachalia JA, I think the second one was Wallis JA, and the other one is NAFSA ADJP. And they all say this paraphrased. When you give, and we're now, my lord, busy really scrutinizing the letter of reasons that is given by the JSC. And I'll show your lordship that that letter is not worth the paper it's written on. We've dealt with the Section 18 thing. Now, in this phase, my lord, that line of cases says makes the following simple proposition: if I do something, and then my learned friend, I'm an organ of state, says, "Why did you do the something?" and give me reasons. Then I give her reasons A, B, C. Then she challenges the
This is the reasons that you gave at the time.
Absolutely.
You can't supplement your reasons.
You can't, and in the answering affidavit, yes, that's the principle.
Yeah.
So what Justice Kachalia called the ex post facto rationalization in the answering affidavit must just be chucked out. It doesn't count. Yes, your lordship got the point.
Yeah.
So, contrary to that noble principle, the JSC tells us that no, after we gave you the reasons, we then went and did some research, and Mr. Hlophe says, I then went and spoke to each division and what have you, and then they give us a litany of reasons why the order should not be
Aren't they just trying to talk about the balance of convenience?
Yes, no, I know, my lord.
I'm not sure they were being proffered as considerations that were present to the JSC's mind when it took the decision not to postpone.
No, my lord.
What they're saying is the balance of convenience doesn't favour you.
I appreciate that,
Yeah.
but well, then that's even worse, because if that is so, then again, it's that thing of elevating the alternative. Then we must check it out for that reason, because it's got nothing to do with the real case, which is the declarative.
Right.
Right. If and only if we ever get to the alternative relief, then all that might be relevant. So otherwise, all that is just completely.
But I certainly,
and I appreciate it.
you can certainly take it from me for the purposes of your argument, but I don't. In order to consider whether the JSC's decision was rational, it would be a mistake to ascribe the facts given in Mr. Nlukai Toby's supporting affidavit to the people who made the decision, or to say that to find as a fact that all of this was present to their mind at the time they made the decision.
That's a hallelujah moment.
What was present to their mind is what they told you.
But absolutely. No, then we're fine, my lord.
In their letter.
Yes, no, then we're done on that one. I promise you, I won't even breathe a word about it. Yeah. So if we then go back to the letter, you'll find that, my lord, irrespective of the, lawyers can dissect these things, but really there's one reason in that letter, and it is that the JS, or rather, the full court did not kick Dr. Hlophe out. That then takes us, my lord, to the cases, to the authorities. The authorities,
yes, sorry, just to sum up so I know where you're going.
Yes, my lord.
On the basis that the question of the rationality of the JSC's decision must be determined by assessing the reasons they give in the letter.
Yeah.
You really only want me to find that paragraphs 2.1 and 2.2 of the letter are just wrong, and that renders the decision irrational.
Absolutely, my lord.
Yeah.
And not, as your lordship knows, and I don't want my landed friends to think, and I know your lordship that's not what your lordship means. But when we say wrong in this sense, we don't mean in the appeal sense.
No,
We mean material error of law. Yes.
There's been a misconception of a basic.
Absolutely.
Your case is that there's been a misconception of a basic factual or legal proposition that has tainted the rationality of the JSC decision, and the two respects in which you say there's a misconception are essentially spelled out in 2.1 and 2.2 of the letter.
And the preamble, my lord, that's where they talk about section 18.
Yes.
Which we have covered. Yeah.
Yes,
so
okay.
if you want to be generous, my lord, we say there are three reasons they've given. It's the 18.2 reason.
Yeah.
The second one is the non-setting aside of Dr. Hlophe's membership. And then the third one is really the same as the second one, where they say the full court has interdicted from participating in the process. It's expressly found that Dr. Hlophe's absence would not render the JSC's decision operational. That's just wrong. That one is wrong in the true sense. Let me tell you why, my lord. Because your lordship knows that at paragraph 56, I think, of the judgment. That last one is just, it should take 1 second to deal with it. Yes, it's paragraph 56, 02-66. What the JSC, I won't ascribe any deliberate intent to it. Let's say it's a material mistake. Yeah. They said, the court there said the respondent's submission that the JSC would not have a quorum in order to take a valid decision if Dr. Hlophe is interdicted from participating in that forum is incorrect. Well, I can tell you, my lord, for free that we never made that submission, but that's not for you, that's for the appeal court. Yeah. But assume for now, for present purpose, that we did. The court then goes on to say that in the premier case, the issue was whether the premier's attendance was necessary, and the court concluded that it was, which is correct, by the way, and we rely on that very heavily.
Yes.
Yeah. Now, the mistake that everybody makes is to conflate two simple things that are not the same: quorum and constitution or composition. We accept, again, for the avoidance of any doubt, if anybody wants to accuse us of saying the absence of Dr. Hlophe is going to affect the quorum of the JSC, well, I'm saying here loud and clear, no. We accept implicitly that the quorum will not be affected. What is affected is the proper constitution of the body, in our respectful submission. Yes. That's all. And those are two unrelated things. So again, when the JSC then says it needs 2.2, my lord, that the High Court found that it doesn't matter. Well, you can just scratch out 2.2 because we agree, but that cannot be a reason to deal with what we are raising, which is composition. Yeah. So that's why I say, in reality, we are really left with 2.1. Now, my lord, let me just make another point, which whatever I do, I must not forget. And this deals now with what I was saying are the authorities. Yeah. I'm now on the second leg. The interpretation points I've dealt with all, my lord. On the second leg, which is what we call unjustified exclusion. Yeah. This is the case of the other side, and I'll show you how fallacious it is. They say, and you can see how clever lawyering constructs this argument. So they say, yes, we accept that in the SCA has twice said in Premier and in Bar Council that the composition of the JSC is all and for one. Everyone must participate in the decision. They say we even accept that principle comes from the old cases, Ski Road and so on, and the lex impossibilia principle and so on and so on. But they say, but the problem is that MK and Dr. Hlophe have forgotten one thing, which is that that court made the qualification that it must be an unjustified exclusion. And then they say, how can it be an unjustified exclusion? Because there's a court order. Very attractive argument at face value. But it is absolutely wrong. You see, this court is bound by the SCA decisions. And to the extent that the SCA, even if there was some discrepancy between the SCA decision and the full court decision, this court would obviously be bound by the SCA decisions. Yes. So I'll concentrate on them. What was said, my lord, in both cases completely assists our case, my lord, and shows that the JSC's reasoning was completely flawed. What was said in the let's start with the Premier case. There, my lord, Helen Zille, who now has flip-flopped and taking a different stance in her affidavit, was saying that the JSC was not properly constituted because she was not in the meeting in terms of I think it's 1K. Yeah. And she then said, well, for that reason, because firstly I was not there as the Premier, but also my alternate was not there. Therefore, the meeting was not properly constituted. And the SCA, for good reasons, agreed with her. And but now she wants the other side of the coin. The SCA agreed with her on the following basis, my lord. The case, and I must concede this, is not on all fours in the following respect, my lord. The gravamen of that discussion was about 178.6, as your lordship knows, the majority or no majority. But in the course of that, the court did two things. It reaffirmed the principle, and that's why Ms. Zille won the case. It reaffirmed the principle that everyone must be there. But it also left open a very important question. You'll remember, I think it's paragraph 21 of that judgment, Melon.
Yeah.
It was raised by, or rather, the court accord, Jones J, had also made Ms. Zille to win the case on another aspect. And that aspect was this. Ms. Zille had raised the following point. She said, one of the advocates that are in 1E had not yet been appointed, and therefore the body was not properly constituted. And she was right, of course. Again, nothing to do with the quorum, but the constitution. And the court said, because we have already found that she's right on the primary ground, we're going to leave open the second one. So which means, as we speak, that finding of Jones J, that even on the second leg she was supposed to win, stands. Or at least it was not overturned by the SCA. I can't put it higher than that. Now, so what does that do, my lord? Two things. One, we must remember that our case is stronger. I'll tell you why it's stronger than both the Bar Council case and the Premier case. In both of those cases, my lord, the so-called absent member of the JSC was somebody who was allowed to have an alternate. In this case, there's no such, and that's the kind of thing Mr. Ngalwana was alluding to. The delegation, the delegation of 6 in 178(1)H must be as it is. It's a half a dozen, or it's all or nothing. They are not allowed to even have alternates, unlike all these other people. The judge, the chief judge, even the judge president and the premier and so on, those people are allowed to have alternates.
Yeah.
But here, it's you have to attend personally, or you must not be there. So that's a crucial distinction, which makes this particular case distinguishable in the positive sense, in that it's even...
Notionally, the National Assembly could elect someone else, but then they'd be reconstituting
Absolutely.
the JSC.
The entire squad.
They wouldn't be giving Dr. Hlophe an alternative.
Absolutely.
Yeah.
Absolutely, my lord. Your lordship, that gets rid of something else I was going to say about alternates. Yes. In other words, even this, there's this thing that gets bandied about, oh, what's the problem? MK could simply substitute Dr. Hlophe and put somebody else. No. How? Under what basis? On which constitutional basis? There is no such constitutional basis. The lordship is correct. The only way you could ever achieve that would be to take the entire resolution back to the National Assembly and then have a new delegation, which may or may not include Dr. Hlophe and all that. And that's why in our letter we said, even if we don't accept that that can be done.
It's common ground that the National Assembly would have to hold the election again. If it wanted
Yes,
to replace
yes, no. But it's not. No, it's not, my lord. All these parties are saying they don't know what we are complaining about, because MK can simply somewhere put somebody else. But your lordship is quite correct. The only way you could do that is to revoke the designation. And that's another facility that is used by FUL in particular. Suddenly now, sometimes you surreptitiously do something. Suddenly they talk about designations. There are no designations. It's a designation of the... So that designation would have to be redone. And that, my lord, to be quite honest, was all we were asking from the JSC. We're saying, even we don't agree that you can substitute, but for the present purposes, say you can. We say to them, the Parliament is in recess. The thing is starting on Monday, and even if that thing that substitution was allowable, it can't practically be done. So please postpone, and I'll even be more strict. I'll be much stricter than Mr. Ngalwana. 6 months, 3 months, 2 months, whatever it is. You could even say, okay, we'll postpone for a period of 2 months or 3 months. Within that period, this clarity must be sought. And obviously, we know our courts would accommodate. This is a big issue. the Part B must be expedited, and in that 2 or 3 months, the whole thing will be cleared up, my lord. So that's all we're saying. We're saying avoid all this litigation.
So a 3-month suspension to work out whether Dr. Hlophe can still be on the JSC.
Absolutely.
Not a 3-month suspension for you to choose someone else through the parliamentary process.
Even that, my lord, if you like. Let's say for anything, but we have to be honest to your lordship and say that our advice is that the so-called substitution is not viable. But for the purposes of this case, my lord, assume that it is. Assume that it's viable. So your lordship is quite correct. So we're saying 3 things. We're saying postpone for 2 or 3 months, pending one of 3 things. And again, even this is misconstrued. We say either and your lordship will find that in our notice of motion at 023. The final determination of the appeal against the orders of the judgment of the full court, your lordship knows what that means.
Yeah.
The second one, we say the final determination of Part B of the applications pending in the Western Cape. Let me pause there. Both of those things, my lord, can conceivably be done within a month or 2. I mean, if everyone commits to it, quite frankly. Because the pleadings are there might be a bit of supplementation here and there and so on, exchange of heads. We all know case management could make sure that those cases, I don't want to be overly optimistic, ahead, let's say by November or early December. But the third one is even lighter, my lord. We say the final determination of the main application set out in Part BB. Now that case, my lord, can happen next week, quite frankly, and it can be done, because that case is about one thing only. It's about the exercise that your lordship and I have just done now, which is looking at that letter. Remember, BB simply says the decision of the JSC to refuse postponement in sitting on the 7th is reviewed and set aside. That's it. So it's only about the letter. And then here are the more important words: whichever occurs first.
Yeah.
In other words, next week, in the next 2 weeks, if we set down that Part BB, this whole thing will be over.
Yeah.
Or if we go to the Western Cape High Court, the JP there, the acting JP, and say, please expedite either the appeal or Part B. Again, the thing will be done, let's say, longer than 2 weeks in that case.
Just to get a sense of where this notice of motion goes.
Yes, madam.
If I were to decide that the JSC's decision was rational and can't be set aside,
yes,
what is left of your case?
Yes.
Can you tell me that?
Yes, I'll tell you, my lord. If you decide that the JSC's decision was rational in the declarator sense, yes. Well, that's why, my lord, we have the alternative prayer. So we say,
of course, Part BB would have to fall away.
It may and it may not. I'll answer that, my lord.
Right. Okay.
Just now. Yes.
Yeah.
But because remember there's a whole issue about Rule 53 and what have you in BB. But I'll work with your lordship. If your lordship were to say, as your lordship might be entitled to, if your lordship were to say, look, the decision, I'm not giving you the declarator because I agree with the JSC's thing in the letter. I
don't have to agree with it. I just have to decide it's rational.
Yes, that is rational. No, I mean it in that sense. It's like that right and wrong thing. Yeah. Then your lordship, the impact of that lordship's order may or may not be to render academic assuming there are no appeals. Remember, it's a final order. Oh, by the way, let me clarify that, because this is said as if it's an insult, as if no. It is. Paragraph 2 is seeking a final declarator.
Yes.
There's no two ways about it.
That's how I understand it.
It's not they say, as JSC says, as we want them to believe that is interim. No, we don't want them to believe anything. So your lordship is quite right. It's conceivable that a granting or even a refusal of paragraph 2 might render the second part to be academic. But that's not important for the purposes of it's important for the second question that your Lordship asked me, which is what happens then.
Yeah.
So that's the first thing that might happen. But what will certainly happen is that the prayer 3 will then have to kick in. And that's why prayer 3 starts with the words alternative to prayer 2.
Yeah.
In other words, if we fail in prayer 2, then we say the interdict. And the interdict is asked for, and let me get into that, my Lord.
So your prima facie right that you assert on when you ask for an interim interdict is more extensive than the right to a rational decision from the JSC. Is that what you're saying?
Yes, my Lord.
So
And
you
the
rely
test,
on other rights?
yes, and all these things about, the courts are going to fall apart and what, they then come into it. And your Lordship would do.
Well, that's because it's an interim interdict and the balance of convenience
absolutely
is relevant.
it comes exactly.
But the whether or not the courts are going to fall apart.
Yes.
So what are, other than the right to a rational decision from the JSC, what rights?
Relief we seek. Okay.
What rights do you rely on for the purposes of the interim interdict? I suppose is the question.
Yes, my Lord. Can I, if your Lordship allows me just to do this first?
Yes, please.
I'm going to address that question of the alternative, but let me just wrap up the first part, my Lord. If your Lordship grants paragraph 2,
Yeah.
then your Lordship obviously then will jump paragraph 3.
Yeah.
And then what we want your Lordship to go, you then go to paragraph 4,
Yeah.
which is what I want to address there. So your Lordship would then grant appropriate, just and or equitable relief in terms of 172(1)(b, which we discussed, and that is the main, and or section 38 of the Constitution. And here's the important part, my Lord, including the interdictory relief set out at prayer 3. In other words, the Lordship may, in the wide discretion of just and equitable remedy, the Lordship might say, don't sit on Monday. But the Lordship could say something else. The Lordship could say, as Mr. Ngalani said...
Well, I understand your submission to be, if I grant paragraph 2, that's a final order.
Yes.
I am then at large
Yes.
to exercise an equitable discretion.
Absolutely.
To make an appropriate order.
Yes.
May include interdictory relief or not.
Yeah, absolutely.
To give effect to the consequences
Of that
the
illegality.
declaration.
That's correct.
Yeah.
That's all, my Lord. So
Yeah.
that's the main relief, dusted,
Yeah.
done and dusted. Now let's come to your Lordship's question.
Yeah.
If all of that doesn't materialize, then your Lordship say, well, then what? Then we say, my Lord, that there are 3 grounds, and I'm going to eliminate 2 quickly now. There are 3 grounds upon which your Lordship could still grant the interdict. One is that your Lordship would there's a case called Owesome van Warmelo.
Yeah.
We've loaded it up and it's referred to in our heads.
Right.
In that case, my Lord, and also this was reaffirmed in the impeachment case that we did I even think your Lordship might have been there. But in the impeachment judgment, your Lordship will remember that the...
So who were we impeaching?
The first respondent's president.
I don't think I was there.
Yes, maybe it was the UDM case, yes. But, my Lord, in that case, the Constitutional Court affirmed this principle of chapter J of Owesome van Warmelo. Actually, in another case, I was trying to say that matter was wrongly decided,
Yeah.
but it is the law. Here's the law, my Lord. Van Warmelo says that the conception that... Can you get me in the heads? No, but where is it in our heads? The passage quoted in our heads, your Lordship will see it. I'm paraphrasing, says this. It is not true that you can only do 172(1)(b) if you find in our favor in 172(1)(a). Yeah, it's in paragraph 19, page 19-12, 112, paragraph 122 of our heads, my Lord. And it reads as follows. I won't read the whole thing. says the remedial power envisaged in section 172(1)(b is not only, and the word is only, is not only available when a court makes an order of constitutional invalidity of a law under conduct under section 172(1)(a. So, Musanaka DCJ in that matter.
Well, it's when deciding a constitutional matter within my power.
Yes.
And that obviously goes much further than those two.
Absolutely.
Yeah.
All of us, until that point, we thought the key to 172(1)(b is that you must have the declarator in 172(1)(a. But Musanaka DCJ said no. The wide powers of the court are not confined to, you may not get your declarator, but the court can still. So that's the first basis upon which this court, my lord, could grant let's call it the relief in four, including, the court could say, for example, I'm giving you this interim relief, but it's for 2 months. And in that 2 months, you must, what Mr. Ngalano was saying, in that 2 or 3 months, you must have done everything, and you must come back here. I've
got that. What I'd like to zero in on is if I were not for any reason to be convinced that you're entitled to paragraph 2, is there any other basis for an ordinary interim interdict? What other prima facie rights do you rely on?
No, my lord.
Do you or don't you, I suppose, is the question.
No, my lord. That's why I'm raising this case. I'm saying, even if your lordship is against me on paragraph 2, on prayer 2, your lordship on the authority of Van Varmelo is still able to grant 172(1)(b relief. And on that basis, that 172(1)(b relief may or may not include the interim order that looks like 2. It might be something else, and that's where I was. I think your lordship.
So I'd have to find some sort of.
No, of course, I'm coming there.
Constitutional breach or.
Yes.
Prima facie right.
Absolutely.
A violation. Prima facie violation of a right.
Yes. Yeah. No, my lord, we're together. I'm simply saying, I'm just registering the point that it is not totally dependent on 2. Okay.
Yes.
Put that aside. Your lordship is then right. Now, if we now then confine ourselves into the let's call it the interdict. Whether that interdict comes from 172(1)(b, whether it comes from section 38 appropriate relief, or whether it comes from the common law, for the purposes of this discussion, it doesn't matter. The only thing is that, my lord, if it comes from 172(1)(b, your lordship's discussion is much wider. If it comes from 38, it's even wider, because Forze, your lordship will know, Forze says that appropriate relief really means the court can even fashion new remedies that have never been seen under the sun.
As long as you don't reward punitive damages.
Yes, unfortunately, for some of us, or constitutional damages.
Except in
that's
the
another
extraordinary of situations.
It is more than extraordinary. Forze was my first case in the Constitutional Court, 1996. But unfortunately, the court said no constitutional damages. Subject to that, yes, Forze says that. So your lordship's hand, in terms of 172(1)(b or 38, is really that wide.
Yeah.
Of course, when it comes to the common law remedy, then it's a little bit more restricted, because then you have to take into account outer and so on and so on. All the things that Mr. Ngalana was dealing with. Although, in my respectful submission, even on Mr. Ngalana's submissions, which he eloquently made on the common law relief, we should succeed. But a fortiori, if that is even remotely possible, then certainly on 172(1)(b and 38, we must succeed. But let me zero in on your lordship's question.
Yeah.
You see, in this realm, my lord, my work is much easier. Because once you are here now, I no longer, as I heard now, just now, have to say to your lordship, Dr. Hlophe's Section 19 rights were violated. What are Dr. Hlophe's Section 19 rights? His right to participate in the activities of a political party of his choice. That's obviously been limited by the non-postponement decision, and that can be debated. MK's right to have its member participating in the JSC, another Section 19(1) right, that's obviously also been prima facie at least infringed. Dr. Hlophe's dignity right to work and do and be a meaningful citizen that does self-worth will be implicated. Dr. Hlophe's Section 34 rights, my lord, to appeal, which goes to the whole debate we've had about Section 18. So I could do a catalogue of Dr. Hlophe's rights that will be implicated, including his right to have a rational decision from the JSC and all that. All that, my burden is lighter in the following way, my lord. Now, all of a sudden, all I have to convince your lordship is that those are prima facie rights open to some doubt.
Yes.
Whereas in the previous section, I had to show your lordship that those were actual rights.
Yes.
So now it's even easier. It's plain sailing, because your lordship could say, well, I'm not sure if the right to participate, but you know, it's open to some doubt. But your lordship would still have to grant the interim relief. Couple that much lighter burden, my lord, with everything that Mr. Ngalwana has said about, for example, the impossibility of removing a judge who would be unconstitutionally appointed. All sorts of things, my lord, and I don't want to be alarmist. The kind of litigation that could come from the people who lose, not lose, who are not appointed next week.
Yes.
Because they can say, oh, well, this thing was improperly constituted, and also, your lordship gets the point. There can be a whole lot of things. And that's why we said in our letter, please, JSC, postpone for a short period to avoid a litany of possible litigation. The mind can go as far as it can as to what kind of chaos could happen. And that's what we call if the constitutional crisis that has been precipitated is allowed to continue.
Yeah.
So what's wrong with that, my lord? What is wrong with saying, please postpone for a month or two, put everyone on terms, and then come back and report to the court, so that all of these things, so that Dr. Hlophe's right to participate is protected, my lord. His Section 19 right. And
just address me for a moment on the proposition that those rights have been limited by the full court, not by the JSC.
No. Yes, thank you, my lord. No. That's a big
It's
mistake.
going to be important for your
No,
colleagues to hear what you have to say
Yes,
about
no,
that.
of course,
Yeah.
because we know it's coming.
Yeah.
That's a fallacy, my lord. What we're here about, as I said at the beginning, is not to assail that court. What we're here about is to assail the JSC's decision. The exclusion of Dr. Hlophe from the meeting next week is not as a result of that court order at this stage directly. It is as a result of the decision of the JSC unreasonably and irrationally not to accede to the postponement. That's a crucial point, my lord. And
this is why I wonder whether the additional relief you seek doesn't ultimately collapse back into the proposition that the JSC was irrational.
No. Of course, my lord.
The JSC's position is that
They're bound.
It's bound by the full court's
Yes.
order. The full court's order placed Dr. Hlophe under restraint.
Yes.
If that order does engage the constitutional rights you rely on, then it's the order that has stopped Dr. Hlophe from going to the JSC, and the order binds the JSC.
Yes.
So either the JSC is right to draw that conclusion, rationally to draw that conclusion, or it isn't.
Yes.
If it isn't, then it's irrational, and paragraph 2 follows.
Yes.
But if it is, I wonder how you can impugn the JSC as having violated any of Dr. Hlophe's rights.
No, my lord. Please, Your Lordship, just if you don't hear anything I'm going to say, just hear this.
Well, I've heard a lot.
I know.
I will listen. I'll listen to what you're about to say.
Just this, my lord.
Yeah.
Remember only this.
Yeah.
Only this. Why we are in this court before you, my lord, this sunny Friday, is because the Judicial Service Commission refused to accede to a postponement decision. Now, and was saying, my lord, what excludes Dr. Hlophe, okay, put it this way, my lord, let's flip it. If the JSC had acceded to the postponement decision, Dr. Hlophe would not be excluded from the sitting next week.
Yes.
Okay, so fine. Now, and if the JSC had acceded to the postponement decision, let's say maybe even with conditions, what we're asking from your lordship, and say, okay, but we'll only give you 2 weeks or 2 weeks or 2 months or whatever it is, Dr. Hlophe would not be excluded from the sitting. So the proximate cause of Dr. Hlophe's exclusion from the sitting next week is the JSC's decision. That's it, my lord. It's not, of course, if you want to do the normal causation thing, you can say the sine qua non is the court order. But the real cause is the JSC decision. Yes.
Thank you. I have the point.
You've got the point, my lord. And my lord, let me then quickly go to paragraph 21. No. Because we don't have time, I'll go to paragraph 35 of the Cape Bar case. I'll read it, my lord. The Cape Bar case, yes.
Yeah.
SCA. Yes, says acceptance of counsel's argument. This was now a criticism of the JSC council when they still thought composition means everyone must sit, but they've also changed their stance. It says acceptance of counsel's argument for the JSC that matters relating to specific high court could be determined in the absence of the judge president of that court and the premier of the province concerned, or an alternate designated by both of them, which would be in direct conflict with the provisions of section 171K. What is more, I believe...
Give me the paragraph number.
35, I'm sorry. 35,
yeah.
yes. Yeah. I'm now in the middle. Yes. I've just read the first long sentence.
Yeah.
It says, what is more, I believe that it is clear from section 178 of the Constitution that the JSC has been created in a structured and careful manner. Its composition obviously sought to ensure that persons from diverse political, social, and cultural backgrounds representing varying interest groups would participate in its deliberation. And here's the killer, my lord. Any interpretation of section 178 which would allow decisions of the JSC to be validly taken without the unjustified exclusion, there's that expression, of one or more of these interest groups would therefore negate the very essence of the constitutional design. That is what we are here about. That careful constitutional design will be completely negated if there is an unjustified exclusion. And since we have already agreed about the approximate cause, the unjustified decision, unlike what my learned friends are going to tell you, is not the court order. Because they're going to say, oh, well, how can it be unjustified because there's a court order? No. The unjustified exclusion of Dr. Hlophe is the irrational refusal by the JSC of his participation. And therefore, on the authority binding upon you, my lord, of the SCA, your lordship has no option but to find that you cannot allow a situation where the careful design of, remember the careful design is even worse in this case, my lord. Normally they say 2 advocates, 2 attorneys, what have you. Here the constitutional drafters went further. They said 6 members of the NA, of which at least 3, minimum 3, must be opposition. So the Constitution is even more prescriptive. That means, my lord, all 6 could be opposition members, but at least 50% must be. Now we have a situation where it's 40%, even if Mr. Ngalwana's interpretation is wrong. We now have 40%, so that's constitutionally repugnant. Let alone Mr. Ngalwana's point, that you might even have the, unjustified inclusion of the other 5, which makes it even more unconstitutional. So the SCA authority that is binding on your lordship, you'll remember in that case court, by the way, was also a bit not comfortable with this, but it said, but we're bound by Premier. So similarly, your lordship is bound by both Premier and Bar Council. and Your Lordship has no option but to find that the unjustified, irrational refusal of the postponement by the JSC is the problem that Your Lordship must undo, and Your Lordship must simply do, if to put it in colloquial language, Your Lordship must simply do that which the JSC should have done, which is to say, okay, we'll postpone for a month or two or whatever it is, but this and that and that and that must happen, so that there's no threat of any constitutional crisis. Everyone is happy, nobody's excluded, nobody goes to court to do anything, and within that limited period, everything is done. And I can guarantee at least one of the three things, which is the Part BB, as I said, my Lord, can happen in a matter of weeks. The others, I'm prepared to concede, can happen in a month or two, because there'll be exchange of heads and what have you. But on the basis of the relief that is sought here, Your Lordship has to, even if Your Lordship is not with us on the declarator, and I cannot see how Your Lordship cannot be with us on that declarator, but even if Your Lordship is not, Your Lordship, we implore Your Lordship with the greatest respect to simply then fashion, quote unquote, that remedy which will leave nobody, there'll be no chaos. Of course, there'll be inconvenience to all sorts of people, but as I don't want to repeat Mr. Ngalana's submissions, but the balance,
yes, on
balance, that inconvenience would favor us. My Lord, those are our submission. If there's anything else, I will deal with it in reply. But in sum, we say interpretation of the court order of Section 18 of Section 178, and we say if you interpret those three instruments correctly, then it is in our favor. And then we say, give us the declarator for the reasons that have been granted, and then paragraph 4. But we say if we are wrong for some reason, then we have the lighter burden in terms of the alternative prayer. As the court pleases, my Lord.
Yes, thank you.
To Your Lordship.
Thank you, and thank you for just about keeping to time.
Thank you, my Lord.
I'm going to take a 15-minute tea adjournment, come back at noon, and I'll hear from Mr. Mainiche.
As